All right. Good morning, Mr. Dixon. So you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. It's like you're also charged with unlawful carrying of a weapon in the 496. Okay.
On July 10th, 2026, officer was on patrol on I-45 near Beltway 8 and observed a blue Hyundai failing to maintain a single lane and speeding. The officer placed the Hyundai at 61 miles per hour in a 45 mile per hour zone. The officer observed the Hyundai use its left blinker but changed lanes to the right, almost wrecking another motorist. The officer activated emergency lights and sirens to conduct a traffic stop. And upon driver's side approach, officer detected a strong odor of alcohol emitting from the defendant's breath and inside the vehicle. He also observed the defendant to have red, bloodshot eyes. And officer observed a cold, unopened 6-ounce shield beer can in the cup holder and another can open and half empty on the floor. Officer also observed a black 9mm handgun on the passenger seat without a holster. Officer asked the defendant to exit the vehicle to conduct SFSTs. The HGM was 6 out of 6, including the vertical gaze and stagnant Fallon. Defendant was transported to Harris County Jail. Officers waited 15 minutes and they conducted a breath test, which came back at 0.229 and 0.223.
Currently eligible.
It's eligible? Okay, thank you. Mr. Dixon, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. When I say illegal drugs, this includes marijuana. You are not allowed to use it. If you test positive, then I will revoke your bond and put you in jail. Because of the high alcohol and the allegation that you have alcohol in the car, I'm now placing an additional restriction that you are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, then I will revoke your bond and put you in jail. Do you understand? I send notice to DPS in Austin so that every police officer in the state knows if they pull you over, that car doesn't have an interlock, they will put you in jail. If I have to put you in jail, there will be no more PR bonds for you. This is not a revolving door. Do you understand? What is your question? Any car that you drive must have an interlock on it. It doesn't matter whether it's work, it doesn't matter. It's just any car that you drive must have an interlock. Do you understand? Great. We are going to reset your case to give you time to hire a lawyer. This is not a negotiation, man. I'm just putting conditions that I'm thinking and hoping will protect our city. If you show me that you're just not going to comply with it, there's only one place I have for you. I'm not asking much from you. I want my city protected. I'm going to do everything in my power to. Michael,
Yes.
on all DWIs, no alcohol, there are no drugs and a random testing, please. Make sure that there's random testing for all DWIs. All DWIs, okay?
All right, Judge, next is Pop-Up 7, Garza, come on up.
Counsel, do you have an arraignment?
No, Judge, you
No,
don't.
you're.
Okay, let me do the arraignments and then
Sir,
I'll hit
Do you
you up.
mind if I just stand here just to?
Yeah, of
my
course,
notes?
sure.
Thank you.
Garza, come up. All right, good morning, Mr. Garza. So you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 12th, 2026, approximately 1 a.m., officers were dispatched to a dispute with a possible firearm at the 1300 block of Kentucky Street in Harris County, Texas. The officers advised juvenile she would go to jail if she continued. The juvenile screamed, "I don't give a fuck," and the SHPD officer attempted to arrest the juvenile. The defendant quickly approached and placed both his arms on the SHPD officer's torso, impeding the officer's arrest. Responding officer grabbed defendant's arm towards the ground, causing defendant and the officer to fall, causing officer to sustain a. The officer was treated by EMS at the scene.
Wow. They didn't charge him with assault on a peace officer.
Does not look like it.
Mr. Garza, I'm going to find that there's probable cause to go forward with your case. Do you think alcohol or any kind of dope played a part in this? What type of damage? Mr. Garza, I'm not going to place any conditions on you now, but if you show me that you're a danger to my city, it's just not going to go well for you. Do not pick up any new cases. Do you understand? If you show me that you're a danger to my city, it's just not going to go well for you. Do not pick up any new cases. Do Do you understand me? We're going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset and then we'll get you out of here. When you come back, please have a lawyer. Come on.
All right.
All right. Good morning, Ms. Hubert. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be.
Coby at 10955 FM 1960 Road. The defendant, who was ID'd by her Texas driver license, was observed on camera of the business and in person in possession of multiple items in the jewelry section of the store. Complainant stated that the defendant bought some items at the checkout line, but did not attempt to pay for the jewelry and merchandise that was in her possession separate from the transaction. The complainant said that the defendant passed all points of sales with the jewelry and merchandise and then was detained near the first set of exit doors of the store. The total return was $154. $54.
Got it. Okay, Ms. Hubert, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to go to any Hobby Lobby whatsoever for any reason. Do not pick up any new cases. Otherwise, I will revoke your bond and put you in jail. There will be no more PR bonds. Do you understand, ma'am? Do you have the ability to hire a lawyer? Okay, we will give you time and have you sign a reset. We will have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. Yes, ma'am, please. This is a criminal courthouse, man. You speak English, sir? Mr. Ortiz, you're charged with unlawful restraint. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, and you have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On April 12th of 2026 in Harris County, Texas, an officer was dispatched to a disturbance call. The officers arrived at the location and heard a woman scream for help. Complaining witness opened the door and complaining witness stated she had been in a dating relationship with defendant for 6 years and they lived together. Defendant got upset because complaining witness came home late. Defendant broke the case in the living room and stated, "We both going to jail." Complaining witness stated she hit defendant to defend herself. Complaining witness tried to call her coworkers to ask for help. Defendant took her phone and smartwatch from her. The defendant prevented her from getting to the door when police arrived by physically restraining her. Defendant held her mouth while she was screaming for help. The complaining witness felt pain from the altercation. The officer found complaining witness's phone and smartwatch in defendant's pocket. The officer observed injuries on complaining witness, including a bruise on her wrist, a bruised lip, and a bloody left ear. The officer spoke to witness, a neighbor who stated he heard a bang and loud arguments.
Mr. Ortiz, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. This includes marijuana. If I find that you're consuming anything illegal, then I will revoke your bond and put you in jail. You were also ordered not to have any contact with this person, not to be in possession of any weapons. When I mean no contact, I mean no contact of any kind. Social media, phone calls, text messages, going to where she lives, going to where she works. You're not to go within 1,000 feet. You understand? If you violate this, I only have one place for you. You have already missed court once. Every time you miss court, I will triple, quadruple, quintuple the bond. Do you understand? All right, Mr. Ramirez, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July.
Mr. Ramirez, I'm going to find that there's sufficient probable cause. I'm ordering you now as a condition of your bond not to drive. You will be signing an affidavit promising me you're not going to drive. I really don't care what you have to do in this life. You cannot justify getting into a car for any damn reason. Not only that, you're on felony probation. When you're on probation, you're supposed to live as if you have a halo. Otherwise, it's very possible they file a motion to revoke. Do you understand?
I have an attorney already.
Oh, you do?
Yes, sir. I don't know, you like, it's Marco, Raj,
A drug aid?
yeah,
Okay. Do you know if he's going to be here today?
supposed to be already.
Come on. Don't drive. I don't care what you have to do.
This one.
Judge, is that gonna be state sponsored?
Yeah, do you mind filing no driving, please?
Yeah.
All right, Judge, top of 13, Rivera.
You speak English, man? Would you prefer a translator?
All right, Judge, below that one on 13, Rodriguez.
Your Honor, I'm gonna read slowly this time.
Yeah, when they get here, please. Dang, you're on probation.
We'll let you go in. Hey, Joseph, did you want to approach on yours?
Sure.
So, top of 14, Salazar. I didn't know this.
Good morning, Mr. Ruiz.
Good morning, Your Honor.
So it's not circulating.
How are you? Happy Friday.
Why does your list all?
Ruiz. All right. Good morning, Mr. Salazar. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 12th, 2026, at 1:02 a.m., an officer captured on radar a motor vehicle going 48 miles in a 30-mile-per-hour zone on a public roadway in Harris County, Texas. The officer conducted a traffic stop and noticed slurred speech, glassy, bloodshot eyes, and the defendant stated he had 2 small beers. The SFSDs were conducted and they were 6 out of 6 on the HGN, 7 out of 8 on the walking turn, 3 out of 4 on the one leg stand. The DIC was read and the defendant conducted a blood draw at 2:10 a.m.
Okay. Any prior to be honest?
There was no criminal history on it.
Wonderful. Mr. Salazar, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using alcohol or drugs, you will go to jail. I will revoke your bond. You understand? All right. Because you have a lawyer, I will waive your appearance. You don't have to waste your time come to court, but you must stay in touch with Mr. Ruiz. See you, Mr. Ruiz.
Bottom of 16, Stauffer.
Good morning, Mr. Stauffer. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 10th, 2026, in Harris County, Texas, an officer dispatched to a minor accident. The officer made contact with the defendant, who stated to the officer that he was operating his motor vehicle when he struck another vehicle that was parked legally on the public roadway. The officer noticed red glossy eyes, a thick slurred speech, and an odor of alcohol from the breath. The SFSDs were conducted and they were 6 out of 6 on the HGN, 7 out of 8 on the walk and turn, and 3 out of 4 on the one leg stand. The DSC was read and he consented to a blood draw.
Okay. Does he have a license to drive? Do you mind checking on Mr. Stahl?
Your Honor,
His license is currently eligible on.
It is?
Yes.
Okay. Mr. Stahl, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. Because this is a second offense, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, you will go to jail. Do you understand? We are going to reset your case to give you time to hire a lawyer. I'm going to have you go sign a reset. We will have you meet with Michael for your bond conditions, and then you'll be on your way.
Judge. Top of 17, Treadwell.
That really sucks. Yeah, I mean, it is what it is. She's been out, so she needs to figure out, does she want to take, the offer that they're doing? Otherwise, we can set her for trial. But it's 500 days and it's time to dispose.
Well,
So,
we've talked and we have a resolution. The state's working on the paperwork.
okay, I'm happy to do it. Yeah.
Thank you, guys.
Just start working on it. Then when you're done, just let us know.
Yes, sir.
Guess who's back? Back again. Ms. Treadwell, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On July 11th of 2026, an officer dispatched to the 2700 block of Eldridge Parkway, Houston, which is in Harris County, Texas. The location is the complaining witness, who was a loss prevention officer of Target, the defendant was seen entering the store and going to the grocery side and making a selection of women's nails and personal clothes care. The defendant was then seen putting the selected items and heading towards the guest services. When the defendant was denied the return, she proceeded to walk past all points of sale. She headed toward guest services, tried to get a return, and when the defendant was denied the return, she proceeded to walk past all points of sales. Target Asset Protection attempted to stop the defendant, but she ignored all verbal commands to return to the security office. The officer was She headed toward guest services, tried to get a return, and when the defendant was denied the return, she proceeded to walk past all points of sales. Target Asset Protection attempted to stop the defendant, but she ignored all verbal commands to return to the security office. An officer saw the defendant walking in the parking lot, detained her and brought her back, where she was positively ID'd. The total was $130.21. The Target Loss Prevention found more items as well, bringing the total to $136.95.
Ms. Treadwell, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to go to any Target for any reason whatsoever. Ms. Gilbert, there is a motion to revoke that's been filed in Ms. Treadwell's case. Do you mind signing it, please?
Yes, Your
Ms. Gilbert, there is a motion to revoke that's been filed in Ms. Treadwell's case. Do you mind signing it, please?
Yes, Your Honor.
You were on probation for a DWI in this court. You have picked up a new case. Guess what happens now? Correct. Exactly. You're not supposed to pick up any new cases. There are other violations in the motion as well. I am now revoking your bond. You will go into custody.
Judge, we have the interpreter.
Okay. Hi, Luis. You ready? Yeah. Ma'am, you're charged with assault causing bodily injury.
Right.
You were facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On July 20th of 2026 in Harris County, Texas, an officer responded to a welfare check at 19220 Cedar Lane. The complaining witness stated that her and the defendant had been in a verbal argument of complaining witness spanking the defendant's child. The complaining witness is dating the child's father, and the father allows this discipline. The two began hitting each other with closed fists. The defendant stated multiple people attempted to break up the fight. The victim stated that she and the defendant were briefly separated when the defendant grabbed a metal paper towel dispenser and hit her in the head, causing a pain of 10 out of 10. The victim stated that she was also hit on the left arm, but stated she could not give a pain level due to being hit in the head, hurting very badly. The officer observed scratch marks on both parties that would be consistent with a fight and being pulled away from each other. The defendant was ID'd through TCIC and driver's license.
Did you say that she was the initial aggressor?
Your Honor, I'm not sure the DIMS say who, I can check to see if the defense report.
And then the other person hits her with a pole. Is that
I
right?
think I think it was the other way. The defendant grabbed the metal paper towel holder and hit the victim. I'll see the defense report and I'll see if we can see if that's.
Are you looking at this, Ms. Gilbert?
I'm looking at it right now.
Who's the initial aggressor?
Report.
Yeah.
It's unclear based on the DIMS, it just says they're hitting each other, which is why I'm looking at the OR right now, and
Yeah.
it
Go
sounds
for it.
very.
Yeah.
In the offense report, it says that Miss Marquez stated that she and Miss Ramirez were arguing, and then Miss Ramirez started to punch her, at which time she fought back.
Ms. Ramirez or Ms. Rivera?
The offense report says Ramirez in it. I think that's the confusion, Your Honor.
Okay. Ms. Rivera, I'm going to find that there's no probable cause to go forward with your case at this time. Okay. Ms. Rivera, I'm going to find that there's no probable cause to go forward with your case at this time. Please be very careful. We have enough blood on our streets as it is. We don't need any more. Do you understand? Okay, please take a seat. Good morning, Mr. Rodriguez. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine.
On July 9th of 2026, an officer dispatched to 125 Weissenberger, number 18 in Harris County, Texas, in regard to a call for service. The officer met with the complaining witness and in Spanish got a statement. The complaining witness and defendant have been in a romantic relationship for 1.5 years. The complaining witness that the defendant becomes violent and physically assaults her every time he drinks alcohol. The defendant began a verbal altercation with the complaining witness, and then the defendant proceeded with punching her across her left side of her face with the defendant's closed right fist and struck her an unknown number of times, causing her pain. The complainant stated that the defendant also punched her across her left arm with the defendant's closed right fist and struck her an unknown number of times, causing her pain and proceeding to pulling her hair and dragging her to the ground. The complainant stated that the defendant told her that he was going to kill her and throw her at the bridge located at the Memorial Herman Park. Defendant stated that this isn't true and nothing physical happened except the complaining witness pushing him. The officer observed the complainant to have a red small bump on her left upper face and red with 3 different bumps, about a ½ an inch, and redness to her left upper arm.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to give you a device that you're going to take with you everywhere you go and prove to me that you're not consuming alcohol. This is a portable breath test device you will take with you everywhere you go at all times. If you fail to blow in the device, I will revoke your bond and put you in jail, and I'm going to make your bond high. I don't know what your status is in this country, but if you're not in this country with permission and you go to jail and immigration finds you, do you understand? You are not to have any contact with this complaining witness, not to go where she lives, where she works, and on your other ankle, you will get a GPS monitor so I know where you are at all times. If you go within 1,000 feet of where she lives or where she works, then likewise into jail you go. Do you understand me? On your way, Mr. Rodriguez, let me make something and I won't want you to hear me loud and I want you to hear me clear. Good morning, Mr. Turner.
Good morning.
Sir, you're charged with 2 cases. You're charged with driving while intoxicated and unlawful carrying of a weapon. You were facing up to 6 months in jail on the DWI and or a $2,000 fine and up to a year in jail and or a $4,000 fine on the gun case. That will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On July 12th of 2026 in Harris County, Texas, an officer checked in with the night shift unit on a traffic hazard call. When the defendant said he did not drink, but there was a mostly empty bottle of Don Julio tequila and an AR-15 in the trunk. The SFSPs were completed and they were a 6 out of 6 for the HGN, a 3 out of 8 for the walk-in, and a 0 out of 4 for the one leg stand. The DIC was red and the blow was 0.115 on both fronts.
Where was he? Mr. Turner, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. As a condition of your bond, I'm placing an additional restriction on you. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, I will revoke your bond and put you in jail. When I say illegal drugs, that includes marijuana and anything that has THC in it. If you use, I will just put you in jail. You understand that, Mr. Turner?
One thing I know is when let's say the bond, the bottle was always in the trunk.
So just don't, you have the right to remain silent. Nothing that you say now is going to change. These are just bond conditions that I'm placing on you at this time. Sir, you're charged with discharging a firearm in the metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney.
On July 10th, 2026, an officer responded to a call for service at 2505 Crestline Street, Houston, which is in Harris County, Texas. This was at 7:02 in the morning. The officer noticed a visibly distraught witness who was the defendant's mother, and defendant who appeared intoxicated and hostile. The officer then noticed several 9mm expanded shell casings all around where the defendant was standing in his driveway. The officer then detained the defendant. The witness stated the defendant was firing the gun into the ground, and the witness gave permission for the defendant to enter the house, and the officer found a firearm. The witness stated the defendant had arrived home intoxicated and got into an argument with his wife, who left, and then witness stated that at that time, the defendant went into his room where she believes he grabbed his firearm and then went outside, and that is when she heard approximately 12 gunshots. This occurred in a metro area that was greater than 100,000 people.
So do we have a witness that sees him firing? Is that what you said? Mr. Veloz, I'm going to find that there is probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to test you to make sure that you're not using. If you do, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
You were also ordered not to be in possession of any weapons. Did they confiscate the weapon? Do you know? Veloz. Good morning, Ms. Williams. Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On June 28th, 2026, in Harris County, Texas, an officer dispatched to a hospital in regard to an assault. The officer made contact with the complaining witness, who stated the defendant was a friend of 2 months. The complaining witness said the defendant and her were arguing about a previous assault that occurred to the defendant by someone else. When complaining witness decided to Uber home, and the defendant told her to leave immediately, not to wait outside.
Well, okay, hold on. She was Ubering home or the other one was Ubering home?
Complaining witness was Ubering home.
Okay.
And defendant wanted her to leave at that point. Defendant, and it was having a wait outside. Defendant then exited the residence and intentionally struck her on the back of the head approximately 15 to 20 times with her fists, causing pain and bodily injury. The defendant said the defendant then attempted to grab her hair and slam her head into the concrete, but was unsuccessful after the complainant's wig became detached.
Oh.
This was until another individual stopped the assault. The officer observed injuries consistent with the account, and the defendant was identified by Texas driver's license.
Ms. Williams, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You were ordered not to have any contact with this complaining witness and not to be in possession of any weapons. If you have any contact with this person, and I don't care what the excuse is, I will revoke your bond and put you in jail. You got a PR bond. We gave you a free one. This isn't one where you're going to get free after free after free. You understand? I'm going to protect my community. You endanger it. It's just not going to go well for you. They need to get the evidence. The evidence is going to point to whose side is correct. I don't know. I wasn't there. Right now, I'm putting conditions, number one, to ensure public safety. Ensure that you don't pick up any cases, new ones. Otherwise, really, you understand? All right. Do you have the ability to hire a lawyer? We'll give you bond conditions and then they'll have the name on it. Okay? All right, please. Do not leave until you sign the bond conditions as well, okay?
I would like for him to explain the issues that he's been having with the device, because when I'm looking at it, it's not making any sense. There have been, this is like, obviously this is his first one, but.
It's not his first one. He had a bond violation in June.
Because it's listed, I have the email as.
He was supposed to do AA meetings and he hasn't done it. And the pretrial has tried to get a hold of him and he's been unable to.
I informed him that he might be going into custody today, but before that, is there any way we can possibly do a scram device instead, just to give him a chance?
It's 220 days old. We set cases for trial at 180 days. I gave you a pass the first time. You don't get multiple ones, man. Otherwise, I become the enabler. Do you understand? All right, goes with you. You're going to jail today. I'm sorry, but I don't know, it's 213 days. Are you just now, or how long have you been on the case? All right, good morning, Mr. Henderson. Sir, you're charged with possession or use of a criminal instrument. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
On July 9th of 2026 at approximately 3 a.m. in the morning, officer observed a Chevrolet Tahoe back into a dark parking space behind this troop center at 19801 block of Gulf Freeway Webster in Harris County, Texas. The officer knew the vehicle to be a suspect vehicle associated with several recent copper thefts being investigated. Officer conducted a traffic stop after IDing the defendant's passenger investigation. The defendant stated he had parked behind the strip to work on his vehicle. The other officers located a freshly cut section of fencing adjacent to where the Tahoe was previously observed to be parked. The officer requested and received consent from the defendant to search the Tahoe, where officer recovered bolt cutters, fence cutters, a handsaw, pliers, double insulated gloves that appeared to be sweaty from recent use, binoculars, loose wire, and copper. Based on the officer's training, these items are commonly used in the commission of copper theft offenses. After Miranda of both defendant and Quint, defendant invoked his right to counsel, but Quint voluntarily agreed to speak to officers in hopes of charging consideration. Quint admitted to acting as a lookout for defendant at 4 copper thefts under investigation and independently ID'd photos of victim locations shown to her by officers.
What time of day or night was this?
This was at 3 o'clock in the morning.
Mr. Henderson, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. I'm going to test you like crazy to make sure you're not using, Mr. Henderson. And if I find that you do, and I don't give a rat's behind what it is, you will go to jail. I see this and I see what you're on bond. I have no problems making your bond upwards of 6 zeros, 7 zeros if need to, for me to protect my community. Do you understand? You will get a GPS monitor, and I'm now giving you a curfew of 7 p.m. to 7 a.m. You are not allowed to go out at night. You go out at night, and I don't care if it's to have a smoke, you will go into custody. Do you understand? Test next week, please, randomly. We are going to reset your case to give you time to hire a lawyer. Mr. Henderson, there are no mistakes in this life. There are choices. You either make a good choice or you make a bad choice. And do you understand me?
Yes.
That's it, Judge.
Okay. Hey, Shatoria,
Yes.
are you ready? Yeah, I don't know. Who did you send? Did you send the documents today?
No, so he's gonna do the community service this weekend. He already has the driving course completed.
Oh, this is the guy that we've been rolling day for day?
Yes, Judge.
Did he get it done?
He'll be done pretty soon.
Okay, all right. So, hey, Palomino, Monday. He's had plenty of time. I'm not going to continue to just do the same thing over and over, man. It's not you, Joel. It's your client.
Do I have to check in on Monday?
Yep. And he will. I mean,
Judge, if I'm at another court, how do I mean,
well, have him give the documents to you. And then you guys can, whenever he gives it to you, you can email it to the state and then they'll dismiss it. But
okay,
it's got to be here Monday.
okay, thank
If
you,
he
Your Honor.
wants to get this done, I'm not going to continue to perpetuate it.
Okay,
Okay?
okay.
All right, man.
May I be excused?
Yes, sir. So he had a bond violation in June. He has a bond violation 7/14/26, and they filed, I guess.
Probably after hours things in that situation. If it pleases the court, either Mr. Long or his mother, Miss Long, will be able to explain that.
I can't even pull it up. I'm having trouble pulling it up.
Yes,
Just the email won't work. I don't know what the hell's wrong with this thing. Okay, I need more than just
yes, sir.
to the hospital. I mean, I need hospital records from him detailing that he was the one going to the
He
hospital,
was with his mother and brother and the information.
but he doesn't have to go to the hospital. If it's,
Look, I feel like it would be insensitive if I explain what happened, and I would prefer if his mother or he could explain what was going on with his family at the time.
sure.
Miss Long,
Hey, can you pull up the GPS records for Mr. Long? And I'd like to know,
at the time.
sure.
Miss Long,
Hey, can you pull up the GPS records for Mr. Long? And I'd like to know, because they're saying that he went to the hospital. Did he actually go to the hospital? How long was he there? Hi, your mom?
Good morning.
Good morning.
Hi. Yeah, we had an incident with my oldest son. He had got robbed and he was shot 7 times. So he did run to the house for us. We waited for the ambulance, but they were taking too long. So we rushed out and Nico did with us as well. So we transported him to the hospital. I do have hospital records stating that we were there at the hospital on the 29th. The next offense, he had to go because he's at HCC. He goes to HCC and our computer isn't working. So he was at one of his friend's house to log in for class. I work for Metro, so I was late picking him up on the 2 instances.
But I understand bond conditions are bond conditions and you can't continue to violate bond conditions without some kind of consequence. This is now a 3rd bond violation. And it seems like there's always an excuse here. It's always an excuse there. It's always a couple minutes here. It's always a couple minutes there. He's not the one that needs to go to the hospital. He's on bond for a criminal case and we've ordered him to stay at home. Nothing good happens for, what is he, 17?
Yes, Your Honor.
At 1 in the morning, 2 in the morning, 12 at night for a 17-year-old out there. And I'm trying to keep him home so that he doesn't get in trouble. And it's like, you don't have any children, do you? I hope to God you don't have your 17. Children, what they do is they push and they push and they push to see what they can get away with. And they do it over and they do it over. Some defendants here act like children as well. They try to push and they try to push to see what they can get away with. It's maybe 2 minutes here, it may be 3 minutes there, but the fact remains is that it continues to happen. And if I
And Your Honor, if I
Take
may
a
be
seat.
heard, on the violation for the 30th and the 14th, she's a single mother and she works for Metro, and Nico actually reached out to ask if he needs to get an Uber or rideshare to get home, and she told him no because she believed that she would make it in time to get him. So while we do understand that
But regardless, we're beating a dead horse. I need to know what those records truly show for now. So just take a seat, ma'am. Let's get it and then we'll go from there.
may we be excused at this time?
Please.
Thank you.
Herman,
Sir,
hey,
don't shoot the messenger, but I'm trying to avoid a PBR.
it seems like we're here every other day.
Yes,
Okay, what's now?
26, 17, 11, 12.
Wait, what?
He is leaving tomorrow. A different client is leaving tomorrow to Florida to the 22nd. He is a low VAC. In fact, one of the samples came back under the legal limits.
Okay, so we'll give him a portable device and he'll have to take the portable device. Dalton, come on up, Dalton. Happy Friday. Good to see you, man. That's right. Mr. Dalton, good morning, sir. Sir, you're charged with driving while intoxicated and reckless driving. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. And on the reckless driving, up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
We wait on the cause.
I'd like to know the reckless driving and the can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
We wait on the cause.
I'd like to know the reckless driving and the DWI are really concerning.
On
Please.
July 11th of 2026, at approximately 4:22 in the morning, an officer was dispatched to an aggressive driver call near the 1800 block of South San Houston Tollway in West and Harris County, Texas. The complaining witness advised the aggressive driver in a blue BMW had tried to run the complaining witness off the road and was actively following behind them. While responding, the officer observed the speeding vehicle nearly collide with them. Then for around a semi-truck without simulating a lane change. The officer paced the vehicle at 120 miles per hour in a 65 mile per hour zone.
Running people off the road allegedly as well?
The officer identified the vehicle as a black BMW, which closely resembled the complaining witness's description. The officer conducted a traffic stop and detained the defendant for reckless driving. Officer noticed a strong odor of alcohol emanating from the defendant and observed glossy bloodshot, watery eyes. The defendant denied alcohol consumption. The defendant refused SFSTs and a breath skin. The officer conducted a blood warrant drawn at 6:30 in the morning.
So you said he's bloodshot eyes. Did you say odor of alcohol? What all
Strong
did
odor of alcohol emanating from the defendant and glossy bloodshot, watery eyes.
you? Okay. Mr. Dalton, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, I will revoke your bond and put you in jail. I don't care who the hell you have next to you. You endanger my community. It's just not going to go well for you. Because of all this, I'm now requiring you to obtain an ignition interlock for your car. You are not allowed to drive any vehicle that doesn't have an interlock. You violate this condition, then likewise, I will revoke your bond and put you in jail. This is not a revolving door. If I have to put you in jail, just, you understand me? I have no problems making your bond as high as can be, really. Just because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with counsel. If he tells me he cannot get a hold of you, then likewise, I will revoke your bond. For now, we'll have you sign a reset. We'll get you with all the paperwork and then you're free to. Just let us know when you hear from him, you know?
Michael, are you ready?
Yes, sir.
So he did pick up another case in another county? Is that what you said?
No, No, sir. He had been on probation in Jefferson County, picked up the DWI here in Harris, and then they were aware of the Harris County case and were okay with.
It may not be today, it may not be tomorrow, but one day you will eventually regret this. It's now a minimum of 30 days in jail. Do you understand? You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded. I'm going to find you guilty. I'll follow the agreement, sentence you to it. I am going to suspend your license for 180 days. Do not drive until you get a license. Good luck to you, man.
Judge, I've got Julian Borrego on your docket this morning. It's a
Borrego.
BVR. It's his first BVR.
Borrego, come up.
Thank you.
Thank you.
I'm going to
So
put a
if-
scram on him, Victor.
Say that again, Judge?
I'm going to put a scram on him now.
Okay, I understand, Judge. Just so I can explain a little bit, Judge. If you look at the timestamps on the violations, one of them's at 7:54 in the morning. It's apparently. Okay, I understand, Judge. Just so I can explain a little bit, Judge. If you look at the timestamps on the violations, one of them's at 7:54 in the morning. It's apparently a .033. The next one is 10 minutes later. It's a .035. So it would indicate that he clears it completely. It's a .028. And so
I'm now amending your bond conditions to put a scram ankle on your monitor. After this, I have nothing left at my disposal but jail. You are on absolute no tolerance now. I don't give a rat's behind if you're using mouthwash. This case is 170 days old. What are we doing with this case?
we're getting together a PTI package, Judge. We're supposed to be in court next week on the 23rd. And so if Your Honor gives us a couple more weeks,
I'm not giving you a week. If you want to enter into the PTI program, it is your responsibility by the next setting to get all the documents to your lawyer so he can submit them for the PTI program. If you don't have it, then at the next setting, you must either accept a plea bargain agreement or I will set your case for trial. It's entirely way too much drama. And when we do, it's time to, you understand me? You have 1 week. All right, we'll have you sign a reset. Pick any day you want next week, Victor, and then
Judge.
I'll have him come back. He's got to get it to you. Yeah.
I just want to confirm bond conditions on Vohana. I have no going back to the leasing office and no contact with the presenting witness. Is there anything else?
No weapons.
No weapons.
Yeah, no weapons, no contact with the complaining witness, no going back to the leasing office.
Right, thank
Yeah,
you.
that's right.
Went to the restroom, Judge.
So for Mr. Law, current case manager, 629, he was at the hospital from 1 a.m. to 1:42 a.m. He then went to a gas station, and then he was back at the hospital from 1:50 a.m. to 8:46 a.m.
All right.
And then for Mr. Ventura, I'll talk to you about the adding portable device.
He told me that he already had a portable device. I'm denying the travel. I mean, he lied to me. He told me that he did have it. Hey, come on up. Not right now, man. I just got too much stuff. Maybe Monday, afternoon or late afternoon. Yeah, if you're gonna get into evidence and stuff like that.
I don't think I need to for just a PCR.
I have a real problem with Mr. Morales. Mr. Morales, did you hear everything that I told the other gentleman that was up here right before you? Did you? Here we are on your third case, and I've told you to stay at home over and over. The reason is because I don't want you to pick up another case. I'm doing everything in my power, and yet you persist to have bond violation after bond violation. And this is now your probably fifth bond violation. I don't care that you're out 3 minutes past when you should be. The fact is, it's yet another violation. Over and over and over. don't be playing Helen Keller. You know, over and over and over. Don't be playing Helen Keller. You know exactly what's going on, man. Guess what happens now, Mr. Morales? Guess what happens now?
They told me on Monday when I was.
You signed paperwork. And I told you. And I know that I'm not speaking in a different language, man. Over. Push and push. Now I'm going to double all your bonds. Goes with you.
Thank you. Do I resend them or?
25,003 on the DWI, on the assault, and then 1,000 on the police. Huh? Oh, I'm just doubling them all.
Judge, you said 20,004?
25,004.
And then he has another.
Yeah, he's got 3 cases.
So. Oh, it's a 25 range. And then,
Are you ready, Mr. Francis?
yes, sir.
Talk to me.
Hey, Judge, check out Brianna Treadwell.
Okay.
Yeah, she's MRP, DWI MRP, and then she picked up the new theft.
All right. Good morning, Mr. Chapman. Sir, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you can afford one will be appointed to you.
On June 21st of 2026, an officer was assigned an assault bodily injury case for further investigation that occurred at a bar lounge area in Harris County, Texas. The incident is documented upon reviewing the narrative in Texas, and the assault occurred on or about June 21st of 2026. The complainant stated that he was assaulted by his current girlfriend's ex-boyfriend, who he knows by the name Derek Chapman. The complainant stated that he and the girlfriend were leaving the establishment of the bar lounge, and defendant and him had an exchange of words. However, defendant Ballard never threatened that Chapman, but Chapman threatened to hit Ballard. The complaining witness stated that the defendant then punched him multiple times in the face. The complainant, Ballard, said that he did not want to engage and remove himself from the situation by exiting the establishment. The CW said that they exchanged a few more words. However, he never struck or threatened the defendant at any point. The CW said that defendant then left the scene in what he believed was an Uber, and complainant stated that he felt pain when defendant Chapman punched him in the face using closed fists multiple times. Complainant stated that he is still sore from the assault even 24 hours later.
So do you think that alcohol played a part in this? Is that what you were saying?
On June 30th, the CW, the officer again established communication with the CW, the complainant, and he confirmed his original statement. The complainant further stated that he had never met the defendant in person prior to the incident, and that he only knew of him through his current girlfriend. He further specified that the threats were up to the effect of, "Man, I will knock you out." But he initially did not believe that they would follow through with the threat, the defendant would follow through with threats. And that the defendant had struck him approximately 3 times with a closed fist in his face and neck area. And he experienced pain and soreness as we have previously stated. He also states it was captured on the surveillance cameras. And then defendant was ID through TC, IC, NCIC.
Got it. Okay, Mr. Chapman, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're consuming, I will revoke your bond, put you in jail. There will be no more PR bonds for you. Do you understand? Also, as a condition, you're not to have any contact with this complaining witness and not to be in possession of any weapons and not to go where they live or where they work. I will protect my community at all costs, Mr. Chapman. If you violate this, you are a danger to it. It's just not going to go well for you. Do you understand? Okay. You guys,
I would say no. It's an assault, and that's not good. Let me check his criminal history. If there's
that's a great idea. Good job. But that's one of the things that you would do when you're looking to see whether someone should get a PR bond. It's a threat. So
Gotcha.
take a look.
It's looking like there's no criminal history. Yeah, so it looks like there's no criminal history, and this was the first time.
Okay.
So, yeah.
What do you think?
If I
You're a gentleman and a scholar. I will grant you a PR bond, Mr. Chapman, but this is not a revolving door. If you're a danger, like I said, I will revoke this bond and I'm not going to give you another one. I will set your bond today at $100. I will grant you a PR bond, but I'm not asking for much, man. If you look at the news, it's devastating how Houston is just ravaged by this and by that and the blood and the killing. It's disgusting. Just be careful. Don't do anything. You know what I mean? All right. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you, then I will revoke the bond. All right. So for now, we'll have you sign a reset. You'll meet with Mr. Michael for all your conditions for your PR bond. And then after that, you'll be free to go. Okay. Oh, no weapons as well, please. Well, nobody, just part of the bond conditions. Okay. Please.
And your Honor, there's like to approach on two off-docket matters on behalf. And we're requesting that because she received a new job that will require her to travel to Minnesota every 2 weeks for her new job.
Is she under bond condition to test? You know, is she ordered not to use alcohol or drugs?
I don't have that information.
No, I don't see it. Yeah, I'm cool with it. Yeah, just make sure that she stays in contact with you so that guys don't lose each other, you know? What else you got?
And then I have Coby Simon, cause number 26076.
Hold on. You ready so file the BVR. I mean, if he doesn't show like he's supposed to and didn't put anyone on notice, that's a no-go. File the BVR. As soon as we get it, then I'm going to order him to appear. And I guess we'll go from there. It's just like how we address everything, but you can't just up and go, not let anyone know, especially if you're on bond for DWI and if you're subject to random testing, so they'll file the BVR and then we'll probably put it on docket for sometime next week.
approach for Ms. Watson. It looks like on 7/15, there was a BVR issue.
On this case?
No, on Watson, Ashanti Watson.
$100. $100 PR bond grant. Mr. Johnson, did you bring your client?
Yeah. Who's the last one?
And I'll sign it.
Perfect.
Mr. Lasco, I'm amending your bond conditions not to have any threatening or harassing contact with the complaining witness in this case. What is threatening or harassing doesn't matter what you think is threatening or harassing. It's what the person perceives. I could care less what you think. So if you go like just to this person, that can be conceived as threatening and harassing, and it can land you in custody. Okay?
Good morning, Your Honor. May I reapproach?
Yeah.
Reapproaching on Mr. Long.
I have a problem.
I'm sorry.
I have a problem with this. Shh. And the problem lies in the fact that we tell you, go home, stay home. You are not allowed to leave. If you have a problem, if there's an emergency, I mean, I get it. It happens sometimes, but you can't just up and go and then go to a convenience store for 10 minutes. Exact thing that I'm trying to prevent is him going out in the middle of the night. And he is out at 1:30 in the morning, hanging out at a gas station. That's not cool. It doesn't, there's no excuse that you can give to justify going to a gas station and hanging out for 10 minutes.
We went there, Your Honor, because they put the hospital on lockdown. So homicide detectives, since I had to go to the bathroom, they said we could go to the store on Huffmeister. Because they had the whole hospital on lockdown.
This is why we have bond conditions
Yes, I understand. I understand.
in a courthouse. We
Yes.
work with evidence. We work with proof. We don't work on gospel, spoken word, promises, faith, this. No, we work on proof. And the only thing I asked was to get your butt and stay home. And yet we're on number 3 and he's hanging out at a gas station at 1:30 to 2 in the morning.
Did they see when they tracked him at the gas station that we went back to HCA on Huffmeister?
Yes,
Yes.
right.
That's only because homicide detectives, when they put the hospital on lockdown, we had to go to the bathroom, so they advised us to go to the gas station that was close to the hospital.
And if they invite you to go to a nightclub just to go hang out there while everything till it dies down? Because on one hand, I understand that you're his mother, but here we are on bond violation number 3. And I just don't think that you can control him. And I don't know if this is a proper environment for him to be in. Because here we are on bond violation number 3. And if I let you go, what's going to happen?
Your Honor, at this time, we just ask that you admonish him and give him another chance, give grace.
I've done that twice before.
Yes, Your Honor.
And here we are again. Am I either speaking Mandarin or am I just, my words have no effect? Because invariably, there's just going to be another excuse. There always is. We're on number 3. Hey, I can't sign the vote conditions. Doesn't let me check it out or get out to sign. I don't know. Just take a seat for now. Let me talk to them. I don't know what I'm going to do. I just don't know.
Yes, Your Honor. May we excuse?
Yeah, please. I haven't even asked your position state, I haven't even asked you to see what your position is either. So just, I guess, think about it for a little bit. Let me get them out of the way and then I'll return.
Your Honor.
I'm okay. I'm not telling her not to go back to the house, but I don't want her to go to the leasing office.
So can she still call the lease? I mean, you know how things happen. at
No.
apartments.
Well, the problem is what happens if the complaining witness answers the phone? How are you not going to know? She's going to have to use someone else, but I'm not going to take her word that she's going to be good and not have any issues. I mean, I just don't want any further action. There's already what appears to be bad blood. I don't want you to pick up any new cases. I don't want there to be any bad blood. I don't want you to accidentally run into this person and then you guys start just, the best way is to keep everybody separated. The reason that we do what we do is so that nothing accidentally happens. So the only thing I'm asking you to do is do not go to the leasing office. But at this point, I just don't think it's a good idea for you to have contact with them. She can go back to the house, just don't go to there and don't have contact with this person. Okay?
And so can they not bother you either?
So I don't know about that. The only thing I'm saying is that don't want you to have contact with this person. If this person should call you, don't answer the phone. If they contact you, don't reply. There are other people there at the leasing office they should be able to talk to you at a minimum. Perhaps Ms. Henley can reach out to them, go, look, we've got this case, we've got bond conditions. If you guys need to talk to Ms. Bahana, please have it someone other than this complaining witness so that they know not to, hey, look, it's probably not a good idea for this complaining witness and Ms. Bahana to have contact. If you guys need to reach her, please have someone else that works at the leasing office do it. I mean, in every case where there is an assault that has occurred allegedly, we always put the conditions on that the person who is charged doesn't have contact with the complaining witness, because it's just a recipe for disaster otherwise.
So she provided a family member's address. That device was then shipped out to a family member's address, and they were then going to provide it to her. There was a delay in this device being sent out to her. Which is why we are here today. She informed me promptly as soon as she knew that she was not going to be getting this device in time. I then emailed call services. They've also been in contact with the vendor who also confirmed that there was a delay in the device being shipped out.
So she was ordered to get the device by
She was working on
1, 2, 3, 4, 5, 6, 7 by the 3rd of July, right? When did she request the device?
that she went to pretrial services the same day because she had to catch a flight back to Maryland that same day right after court. In fact, she caught a flight from Maryland to Texas this morning.
It is elevated to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 3 days in jail with credit for the 3 days that you've done. You need to understand something important. This DWI will go on your record. The full faith and credit clause of the Constitution means that other states recognize from now on, you pick up any more DWIs, it's a minimum of 90 days in jail. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this. If you are on probation or parole, pleading guilty to this you can be revoked, resulting in further confinement. Is this what you want to do?
Yes.
How do you plead to the offense, man? I'm going to find you guilty. I'll follow the agreement. I'm going to roll your forecast so you won't owe anything. But I will tell you, if you pick up a second DWI, a conviction, it's a $6,000 surcharge. And if you don't pay it, every $100 that you owe, you sit 1 day in jail. So be very careful. All right. Good luck, mate. Oh, I have to suspend your license. I'm going to do it for the minimum, which is 90 days. And good luck to you. All right. See you. 90 days. Okay.
And I have one more matter.
You're almost.
This is on Mr. Smith's judge. He also has a BBR. There was a new law violation of POM case.
Is he here?
He is, and I'm not sure if you've already heard PC on the POM, but I would like to hear it on that.
Okay.
Okay, thank you.
Mr. Smith, you are charged now with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On July 10th of 2026, an officer did a traffic stop where the defendant was operating a vehicle with obscured plates, and.
With what?
Obscured plates.
Obscured plates. Okay.
And in Harris County on a public roadway, once the traffic stop was initiated, the officer smelled a strong smell of marijuana, and the officer found it, and it was 2.2 grams, equal to 0.07 ounces. The marijuana is also against defendant's bond conditions. There was another passenger in the car that said it was not his.
Yeah, I think that there's enough probable cause to go forward. Mr. Smith, you've now picked up a new case. You were ordered not to pick up any new cases. I now have to revoke your bond, sir. You will go into custody. As a condition of your bond, your orders not to consume alcohol or illegal drugs. You will be tested 50 days from today. If you can, I told, don't pick up any new cases, Mr. Smith, really. Just, no buts. Just don't pick up. Okay. 5001. I will leave the weed case as is. Amaya, come up. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right.
On July 11th, 2026, an officer with Ortiz Drive, which is in Harris County, Texas. Upon arrival, the defendant was in handcuffs in the rear seat of a marked patrol vehicle. The complaining witness is the witness's mother. The complaining witness arrived at the residence and observed defendant outside with witnesses' belongings placed near the front door. The complaining witness repeatedly told defendant to leave, but he refused to do so until witness sent defendant money. As witness tried to enter the residence, and a verbal altercation began. Once he forced inside, he grabbed the witness by her arm, resulting in a scratch. The complaining witness attempted to close the door when the defendant grabbed the complaining witness's wrist, causing bruising and visible marks. Then the defendant shoved the complaining witness's face with an open hand to prevent the complaining witness from closing the door. After Miranda was read, the defendant voluntarily admitted to grabbing witness by the wrist and shoving complaining witness's face with an open hand.
So that's on one case. He has an assault as well. I just noticed that he's also charged with assault bodily injury. Is there a second complaining witness?
There's an assault of a family member and there's a assault of causing bodily injury, but I believe.
Got it. Okay. Mr. Amaya, I'm going to find that there's sufficient probable cause to go forward on both of your cases. As a condition of your bond, you were ordered not to have any contact with either of the complaining witnesses and not to be in possession of any weapons. If you do, I will revoke your bonds, put you in jail. I will protect my community at all costs. I don't care how old you are. I don't care what color you are. You endanger it. It's just not going to go well for you. Do you understand? You are also not to be in possession of any weapons as well. There is a protective order that has been issued in the family member case. You need to get to know it. If you violate the protective order, they can file additional cases against you. And it's one of the worst cases you can pick up in misdemeanor court. Do you understand? Guys, do you mind filing conditions on Mr. Amaya, no contact, no weapons, so it outlives the MOAP on both cases, please?
Yes, Judge.
Okay. All right. I'm going to have you sign a reset. We will have
Yes,
you.
Your Honor.
I signed your conditions on last go, by the way.
The conditions weren't right. They were the same ones. They didn't say no threatening on that. They said no contact and also there. I think the state is amending them now because they want to use.
Got it. Okay.
Right now, we're approaching on Mr. Theriot. This is the case, they got a little complex. They said right now, he's at the PDR phase of filing this discretionary review because he was kicked or denied by memo from the Board of Appeals.
Right.
So now the move is going to be Victoria's calling tomorrow the lawyer that's going to do both appellate and fugitive because I guess the PD's office no longer does the appellate work.
But really, Mr. Johnson, it is what it is. You know, if you want to, hey, do we gonna find someone to do the PDR one? So roll it for Monday then, because there's time on LASCO. I can just put no threatening or harassing conduct on the bottom and uncheck the boxes, or as far as that way they don't have to do it again. You know, don't worry about it. So what I'll do is I'll just uncheck the boxes, and then in the lowest box I'll put no threatening or harassing contact and no weapons, and then that'll. So you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 20 days in jail with credit for the 8 days that you've done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, deny naturalization. You give up the right to appeal.
In the probable cause, the issue here is that, yeah, he has a PR bond for this, but he has a holdout of Louisiana extradited. In order to.
Got it. By pleading guilty to this, it may revoke that probation or parole because I have just no idea. Do you understand? I'm going to find you guilty. I'll follow the agreement, send you to 20 days in jail, give you credit for the 8 days that you've done. I will roll your court costs so you won't owe anything. And that's it. I would like to send him for a drug and alcohol test.
Your Honor, and it looks like prior to this bond violation being filed, there was a contempt resolution agreement that was going to be in place for deferred adjudication with zero tolerance from well, for adjudication in this court. We worked out a potential new agreement to take into account his GEDs, tolerance, curfew, RUAs.
On a deferred?
On a deferred, yes, Your Honor, for 9 months.
He has no criminal history, right?
He has no criminal history. It would be a last chance, zero tolerance kind of deferred with proof of GED completion.
Were you planning on applying for PTI or anything like that?
No, sir, Your Honor, he is open to this, offer and is willing to accept in the terms of this agreement.
What I was planning on doing is I was going to send him for a drug test right now to see whether he was clean or dirty. And I was going to really base my decision on that fact as to whether he was clean or not. I was probably going to continue supervision, just modifying and adding more conditions. I wasn't probably going to take him into custody, but I wanted to know whether he's clean or not, because I think that's, for me, one of the important things that he's not using. But it's up to you. Would you rather me send him for a drug test? We can reevaluate this on Monday or Tuesday of next week to see how the test goes. Okay, yeah.
We just want to make sure that it's workable.
Yeah. My concern whether he was going to be eligible for a PTI is what my concern was versus the deferred, because he has no history, he's young, and I just wanted to make sure that he's making good decisions, and that's why. I mean, I was 99%, but you make the decision. It's on you. I would most wholeheartedly accept it if that's what you want to do. You guys let me know.
Yes.
Okay?
Thank you.
All right. If you guys don't do the deferred, I'd like to send him for a drug and alcohol test, and then we can readdress it next week to see how it goes.
Yes.
But, yeah, okay.
Thank you, Your Honor.
Yeah.
Yes, so she completed her probation.
She has a warrant.
Exactly, so we just found, it happened on the same day, so this day she completed the probation on 7/15. They filed a 2B warrant for a death charge from before, but it happened on the same day. So they're asking you on the unside of her aside term. Technically, she completed everything. She got her GED, was engaged in mental health treatment, did anger management, she was reporting and she just picked up.
God dang, I mean, really, I mean,
I know. I know.
you're doing so damn good. You even get your GED and now you're done. I mean,
And we just found out yesterday. We can't do a motion, that's a.
that's great. It just sucks that she's in, but
The
okay.
next one is, so she absconded all the way back in 2014. She just picked up a new charge for possession in Arlington. On her extradition warrant, it's limited to 200 miles. So they're asking if they want to change the warrant so they can keep her.
So usually Harris County has 10 days to go pick her up, but because it's far, they're not gonna go pick her up. So in 10 days, they're gonna release her.
Okay.
I'm not gonna give her a PR bond. I mean, I'm not gonna reinstate the bond when she's been gone for 13 years. Okay.
He tested positive for THC, med. And then the last one is
Or wait, should we do a court watch? Okay,
So he's supposed to get out probation September 22nd. He tested positive for cocaine twice. His last UA on the 13th was negative. He said he was having marriage problems and that's why they wanted to extend him with non-sham after due relapse. That's what.
man, how are you gonna say I had marriage problems? So here, let me go do some cocaine.
I know.
Do you really want to go to jail, Mr. Mondragon?
No.
Your alleged actions tell me differently. I am now going to place a scram device on your ankle. I don't give a rat's behind what your next excuse is. Do you understand me? You better know darn well what you put in your body from now on.
You can come sign this way.
That may be interpretive excuse.
Not yet, because I might need you to explain it to Michael right here, please, because you're close.
Bottom of 5 is the item.
8,001. And let me do a VR on that too. Be careful. I kind of messed up. Careful, okay? Watch it. Victoria, are you ready?
For the next one,
Yeah.
I think Ramona needs to.
Um, 2501.
The last one is on 14 and 15.
Yes.
Your comments in forward. The person who finds me out of it, at the time.
He's not answering. Do we have someone we can appoint for now for the?
It's just.
Is Brandon on both of the cases? That's the new case is the DWI.
The new case is DWI, but it looks like last time he spoke with the chief Karina about submitting a mitigation packet for that, so.
When? But the
2026.
but the DWI is a week ago. He was on bond for an interference. So problem is that I have Brandon's number and I text him for purposes.
I'll let you go.
Hey, Brandon's on a cruise. So we'll do the arraignment on the DWI now, and I'm going to set both of them for bond forfeiture for Wednesday. And then we'll address the bond violation on Wednesday, and I'll let him know that now. Do you want Tuesday or Wednesday?
Can she apply for an occupational license?
I don't know. I mean, theoretically, anybody can apply. Will it be granted? That's a better question. Hey, are you guys waiting on us? We're done. Go. We're done. You already, we can never put ourselves in your shoes. You will have a very hard time living in a society I don't know. When you end up with convictions, when you end up with criminal cases, all you're doing is you're making just life more difficult when it already is difficult. It's not easy. This life is about one thing. Close, everything is great, but it all starts right here. It starts with an education. It doesn't start ending up in criminal court with violation after violation. And this way sucks. If you don't believe, no one hires felons. Do you understand? You're charged with evading arrest or detention. the agreement that you have worked out is a 9-month deferred. This is a type of probation that if you complete successfully, there's no conviction on your record. You need to understand something very important. The case does not get dismissed if you complete this successfully. You just do not end up with a conviction. There's a big difference. Do you understand? That's the goal here. The goal is that you make this out in one piece. People who at a minimum don't have a high school education, nothing good is happening for you now. You need to really shape up because otherwise you're going to have a very hard life, Mr. Long. For you to complete this successfully, you must do a Thinking for a Change program. I can keep you here for the next 2 years, maybe 3, who knows how long, and I'm going to keep you until you get your GED. I don't care what damn excuse you have. If you start playing games, I have the authority. They can file a motion to revoke. We can, this deferred all depends on you. The minute you get this class done, the minute you get your GED, I'll take you off. But if you start playing, and when you end up in jail with a $10,000, $20,000 bond, you think she has that kind of money to pay for you? They're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You are stuck with this until you complete it successfully or it gets revoked. If you do, you are looking at a solid year in jail. Mom, as long as he's enrolled in this program, I'll waive the community service. There are no firearms. You are not allowed to have any kind of weapons or ammunition. Do you understand? Is he currently enrolled now in a GED program?
Yes, he goes to HCC. He's been enrolled there for what, a month?
What do you want to do with the rest of your life? If you had your dream job, if you could do whatever you wanted to do, what would you want to do? Really? That would be a great profession. They need firefighters and it's a great profession. That's something that will help you out. They will help you pay for school as well. But you can do firefighting. That'd be great. All you have to do is finish here, get your GED and start looking all you have to do is apply. I mean, when you put your heart into it, you can do damn near anything in this life, really. It's just a matter of, do you really want to do it? If you do, how much do you want it? I was a big screw in high school. I was so bad and I skipped so much classes. I nearly failed every single class in my freshman year. I was such an a-hole to my teachers that they would have flunked me, but they didn't like me and they hated me so much. They said, no. Put that dude in sophomore year because we just don't want him anymore. It took me really having someone put me under, the people that I know now, one's dead, and so for me to get into college and then into law school, it was so much harder for me just because I didn't have that background. But if you have the heart and you have the will, because I do, and no one's going to tell me any different and no one's going to ever stop me. You got that, you can achieve damn near anything for so long. You understand what I'm telling you? You start screwing around, I'm just going to throw your ass in jail. That's all that's going to happen. And I'll do it over and I'll do it over. And we've done it before. I've kept people here for what, 2-3 years until they shape up and fly right. That's what. Oh, Separated, come up. Sorry, I thought it was wishful thinking. Mr. Sepulveda, you're charged with driving while intoxicated. You have not picked up another case. Okay.
Your Honor, Mr. Sepulveda was found driving on a public roadway. The officer observed his vehicle crossing over double yellow center lane dividers, continued watching his vehicle traveling westbound on the feeder road, observed the vehicle fail to signal 2 lane changes as it continued Feldman, who was driving, had a temporary license plate that showed it had expired June 7th of 2026. The officer observed this on July 11th of 2026. Once they conducted a traffic stop on the vehicle, they observed Mr. Sepulveda to have slurred speech, red glossy eyes, and an odor of alcoholic beverage from his breath. He then stated to officers that he had consumed 2 beers within the last 4 hours. They conducted HGN and found 6 out of 6 clues, but Mr. Sepulveda refused the others. They read DIC and he refused to give a sample, so a warrant was executed.
And then does he have any prior DWIs from any other jurisdictions? Mr. Sepulveda, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, I will revoke your bond and put you in jail. As it stands now, I'm ordering you not to drive any vehicle that's not equipped with an ignition interlock on it. Bond, you have picked up a new case. We will have a hearing on Wednesday on the bond violation that you have picked up now. Ms. Hudson.
Good morning, Judge.
Hey, good morning.
I'm approving Coby Simon. It's an off docket case. I have the case number when you're ready.
I think, didn't we talk about that with someone already today?
Yes, my colleague approached this morning for me.
Oh, this
And
is
I
the guy that's working offshore.
Yes. What happened previously was he was supposed to provide his schedule, and so they told, according to him, they told him that he could provide his schedule up to 3 months in advance. So the months passed, so he probably just forgot to update his schedule. I did send that updated schedule to pretrial services this morning. And so if he's not able to take a test today and then they send the bond violation and you require him to come next week, he won't be able to. He's literally.
Michael, can I give you a cause number, please?
There you go. We'll see you on Tuesday or Wednesday.
2607-615. Mr. Simon, we spoke about this earlier. If there is a bond violation, though, a bond violation report needs to be filed because he's supposed to live up to certain conditions. If he's not, please just make a note of it. And in your infinite wisdom, if you see that a bond violation has occurred by not being able to test, not doing this, not telling when he's supposed to be here, please file it and then we'll address it. As far as when we will set him, if there is a bond violation, Ms. Hudson, we will set him for the 28th of this month.
Okay. Thank you, Your Honor.
Victoria, did you get the cause number on that?
Yeah, okay.
It's 2607-615.